Good evening. My name is Hazem Munir. I want to thank the Arabian Organization and the National Council for Human Rights for this workshop and for the topics and the ideas and the dialogues that they have discussed today and yesterday. And actually, it's in a critical point that the civil society proving by these activities it's willing to participate in the development and the progress some of the sides regarding the Egyptian constitution. Today's session will discuss a different side in addition or what was discussed yesterday and the morning session, which regarding the effect of the existing legislation on a specific groups. We dealt with today. Dr. Adel talked in today's session in Al-Azhar University, and he presented a hard presentation, and we really are grateful for that. We are reading and we are listening to his participation through the various and different media and through his conference and workshops that we have participated in, and he is really an asset to any session and to the topic. Also, we have our dear friend Mr. Muhammad Ahmad from the Children Federation, and this federation is the most important dominant organization in the children affairs in Egypt, and it have a useful high class participation in this field. Today workshop or this session will cover two primary topics. The first topic, the effect of the legislations on the psychological and emotional and behavior inside the prison. Also to focus more the people who got a capital sentence verdict or who have long period in the prison as a sentence, the effect of the legislation about on their emotion and their behavior inside the prison. Also, their situation and their detention inside a different unit. How does that affect their behavior and performance and their relations with the society also? We will not have limited sessions, but we will have an open discussion. We will start with Dr. Adel. I want to greet him, and the floor is yours. Good evening, everyone. I thank the Arabian Organization for the invitation, and I thank Dr. Hazem for his introduction, and God willing, we will spend a quality time together and we will benefit from it. Actually, we should be aware that being in prison creates a lot of emotional and physical problems, along with a behavioral problems. These problems are culminating year after year and increase year after year. And actually, when we talk about it, it's not about only the prisoner, because we should take into consideration the prisoner family or relatives. And being in prison affect a lot of sides and things, but also the people living outside the prison are affected, and we will study this effect, because as you know, a lot of us know, they are marginalized by the people, outcasted, ostracized by the people. They got into an emotional prison. As a people move out, move their places, and that these people, we call them the secondary victim. They are affected a lot by this situation. They got an emotional effect, they got social effect, they feel that they are marginalized, ostracized, excluded. Economically also they are affected because their income were limited and decreased. Also they got antagonized and get aggression. They feel injustice, they feel oppressed, so the reaction will be different. What face the prisoner most is depression, concern, and it increase in the first period of the prison and in the last period. The first period because he have a long period ahead, and he try to count it by day and keep count of it. And the last period he was preparing to himself to face reality. Then the interim period. Actually, I was lucky and privileged to visit some of the places which are prisons. But I have visited very important prison in Suez. The prison in Suez was unbelievable, because I can't imagine how they deal this person. There is a great difference between restricting the freedom of the people and how we treat them, what we feed them, how we make them live. Each prisoner have a good place, have his bathroom, and have his food, and have his needs, and the quality of the service of the food is different and good. So they apply the idea that the sentence is restriction of freedom, not humiliation of the life. As a person committed a mistake, we are trying to correct this mistake, not humiliate the person. Then we got into the prison idea, then to the rehabilitation of the person. This person should be able and feel content that he will perceive it as he got a punishment for a certain reason, to protect the society from the repetition and recurrence of this crime. So it's a protective procedure, so he will perceive that as we are supporting him, not fighting him. So psychiatry and all other fields say the quality of life is very important. It doesn't mean how long I live, but what mean the quality of life in the period that I live in. So they try to keep that and protect that in any way. Also, family visit are granted. Fine, the last thing I have seen in this prison, that the superintendent of the prison was a lady, and she was characteristic, she was charisma and decisive, but at the same time she have enhancement and she have refinements in the prison. And the best thing, when she treat me to lunch, they always take into consideration details. The emotional pressure upon the prisoner came from a lot of reasons. First, the individuality idea, that we are individual. We have a lot of common things as human beings, but at the same time we are individual and we are different. When we look to human being, Each human being have its different feature, so we are independent. In the prison, the first thing they do is killing the individuality. Everyone, they have a uniform, they eat the same food, they have the same seat, and they go out at the same time. So they are killing the characteristic, the quality, the individuality in the human being. And individuality is very important. When you feel you are different, you have a special thing, you will feel valued. That's the first thing that you lose in prison. The first shock that the person got when he is imprisoned, that his life is transferred greatly and hugely from a social life to a prison life. This life has a black dot, and also there is an attitude, there is his attitude to deal with the other inmate or prisoners. So unaware, he deal with them as a criminal. And actually it's appeared in his dealing with the others. Sometimes they call them by numbers or by nicknames, so even they lose their identity. By the time they are losing things, also they miss their family and their relation with their families because of the long and separate visits, and that they may be punished by banning their visits or restricting their visits. All of that affecting them because they lose all the relations with the outside world. Lacking of motivation, that means also that they don't have a incentive or motive to do anything or to reach a goal or to develop himself, because he feels that his life is end as he is here in this place, that he will spend 25 years in it and he will get old and die there. Deprivation of some things in the prison, like deprivation or inhabitation of sexual desires. So perversion appear on the prisoners because of the abnormal life. The adolescent in the prison also, or in the detention, or in the their role model as the social attendant or supervisor, and this person, he always be fed up and nervous and perky, prickly, as he have a negative attitude. So he also burden their shoulder with emotional sides and emotional problems, and he teach them cruelty. As I said, the outside family also have affected by that. Because a family member committed a crime or violated the law and got imprisoned. So the family get into outside, reach it to alienation and lead the person to leave the country, or the family may. It also can come down to divorce, where either the son or the daughter got divorced because of this problem. So the family are overwhelmed by a lot of problems because having a single individual as a prisoner. Also it affected the education, as the children are outcasted, ostracized in the school, or even they may transfer from their old schools to less quality, less inexpensive schools. Also, there are economic effects on the children, directly or indirectly. Also, alienation and the distance affect their life a lot, and it appears also in their behavior. People who got a capital sentence actually issuing the verdict and the execution of the sentence, that's mean it can be appealed or revised. This person got into a disturbance and antagonism and aggression and want to revenge and a deep depression, and unfortunately they transfer that to their families. When their family come to visit him, see him, deal with them, he convey that to them, and inside the society the oppression and unfairness, injustice idea that according to his point of view create an aggression toward his family and toward the others. So actually, how can we decrease the psychological, emotional effect of this thing on their life? First of all, the prisons should be reformed, and should be proper. I can't find the proper word, but I think the prison should be proper. When I traveled to Suez, I knew then that a prison can be proper and it can focus on rights and freedom, not humiliation. So they will treat the prisoners in a good way. They are not an enemy, they are just committed a problem, and they are just spending a sentence. So there are a deep difference between someone we are revenging from or someone are doing a sentence. People working on prison should be trained for a lot of things. First, to treat with the innate. Second, to know how to absorb aggression and anger. Also, how to talk with the innate and prisoners. This can be through courses and workshops inside their association. So I can say that they are taught that before they transferred to the prison federation or association. It's very important to know how to arrange that. We should also provide a care for the prisoners inside and outside the prison. We should provide outside that we continue their support outside the prison, and also we should provide a support for the family while their individual or relatives inside the prison. Sometimes we should help them either way. We should also have programs that forming the personality and character of the prisoners and to qualify them and rehabilitate them when they are released. Sometimes we hear about individual cases like someone get into prison and got a master or license in law school, but we want to have organizational role, authority role, systematic role in this part to stop the crime and prevent it. I think the primary work that all of us try to reach is preventing the crime. So police, for example, it's the first object is to stop the crime, not to arrest the criminals. I think arresting the criminals is number two, but the priority is to prevent, to deter the crime. So as much as they stop or deter the crimes, this is the primary goal of the society and law organizations. So how can we have a program forming their characteristic and character, and how to enable them to do something when they are released? Also, all this program should be serious and real and realistic. We should teach them properly. Also, in the health and the psychological side, we should have a periodical check on them. We can't let the sexual disorder or concerns or problems with them and we remain neglected or unaware of that. We can't agree with that. Also, the addiction inside the prison is serious and critical, and we should solve that problem. Also, the psychological health is very important, how people inside the prison be helped to be taken out of their depression. We can't do that without a group of doctors that are trained and expert and skilled in these problems and field. And I know that the doctors heading for the prisons deal with it as a punishment. So if you are a doctor and you misbehave or disobey, you are punished by being sent to the prison and assigned there. So they will do that unwillingly and grudgingly. It's important to how to train them and how to accept this idea. Also, decreasing the number of the inmates or imprisoner number is very important, how to decrease that. So when we have a less number of the prisoners, we can deal with them with better standards of health and service. All of that. Allow the humane treatment for the prisoners. So we will just restrict their freedom, but we don't restrict their dignity. So we are punishing them, but not crushing their soul. We can't neglect any right of his humanitarian rights and human rights. Thanks a lot.
Yeah.
Thank you, Professor Adil. As I praised you from the very beginning, I have not expected that you will transfer us to a different experience. And now we have been psychologically imprisoned. I mean, thanks to your explanation, we have been experiencing the feelings of a prisoner. Now we have recalled many images to our mind, and as if it were real for us, now we have recalled so many events that some of us were really imprisoned, and some of us were just recapturing what happened to them and the recollections of what they had seen And here, instead of reforming the legislations, instead of the legislations to be an answer and resolution to the problems of the people, on the contrary, they have become a matter of a whip or a punishment for the people. Dr. Adil, as he has focused on the concept of punishment, or the concept of a sanction, or a concept of a penalty. Now, how does the Egyptian legislation deal with the punishment? Is the goal of the Egyptian legislation to correct the mistake, or does it have another point of view that, as Mr. Kamil Zohairi, one of the famous Egyptian presenters, he was saying that Egyptian legislatures are punitives, are punishers, rather than they are trying to strike a balance in legislations. What is bad, as Mr. Kamil Zohairi, the ex-Egyptian presenter, has said, that Egyptian legislators are punitives, are punishers. They prefer punishment, they prefer penalties, they are penalizers rather than reformers. This is the point of view of some Egyptian presenters and some Egyptian human rights activists. As Dr. Adil has been discussing the role of legislations and the role of detention and the role of imprisonment and its impact on those detainees, it is very evident that we should have a different philosophy, a different concept about punishment. As it was noticed that the latest legislations did not have a clear vision, did not have a clear philosophy. Thus, we find legislation leading to many problems, for example, and the last of which is the one related to the civil organizations. We were not exactly sure of what the goals are, as it was just touching on a number of problems as it moved from one problem to another, from one ditch to another. This without clear philosophy. As Dr. Adil has explained about the cases, about the symptoms of the cases, we have understood that we need to reconsider legislations in order to know whether I deprive somebody of, is it restriction or dehumanization? This, we should be very clear about it. Do we do we imprison somebody to restrict him of freedom, just to reform him, or the other way is to dehumanize him and you turn him into an animal, into a subhuman, into a savage person who will be hating and hated by society? As Dr. Adil has explained in a very clear point, when you look at legislations from that part, many human sides should be taken into consideration while legislating. This also applies to what Mr. Muhammad Ahmad, the chairman of the Legal Unity for Egyptian Federation for Child Revival and Renaissance. We also have to abide by the rules and the conventions. And when it comes to the child in Egypt, we have the law of child. This is of 2007, 121 of 2007, which is one of the legislations that we are very sure of, that is very clear to the charters and the conventions Egypt abide by and is a party to. There are many important aspects of the legislation. I was honored to work on training media professionals on the details of the the law of the child. There are very important aspects in protecting the rights of the child. Not only general protection, but even to protect him, to prevent him making mistakes, to prevent him, to give him his rights. And I remember once there was the Mansoura event in which a child, Zena, I think, or Jana, was raped, and 90% of Egyptian media at that time were considered with they did not mention the picture, they did not provide the picture, they did not mention the name, because law shall strictly punish whoever publishes or gives details about the child, about his family, and about his family. However, in spite of the latest changes or amendments in the law and being abiding by the international laws, we still need to deal with legislations related to childhood. And as Mr. Mohammed may agree with this, especially when it comes to the best interest of the child, BIC, and the rights of choice and his legal protection and legal rehabilitation, we need many things to be developed, many things to improve, especially at the legislative level. Here is the floor to Mr. Muhammad Ahmed. First of all, before we discuss the prosecution of children based on the latest constitutional amendments, a child as a member of society, every person under the age of 18 is considered, according to the Egyptian law, a juvenile or a child due to the physical problems or to the physical suffering of the people under 18, or the incomplete physical body. We have the UNCRC, Conventions on the Rights of the Child. It was signed by 193 signatories, and they say in the definition that, you know, the age of 18 has been determined after a long study, and they could have said 16, they could have said 15, or any under 18 year old child, but the studies and research papers have asserted and have proven and pointed out that the maturity, intellectual maturity, is fully complete for a child or for a person when he is at the age of 18 to be responsible for his deeds and actions. The CRC has for non-discrimination and efforts for the BIC, and also the rights of survival, also the respect of the opinion of the child. Egypt has signed it on the 24th of May 1990, after it was reviewed by the People's Assembly at the time in Egypt, and it came into effect on the 2nd of September 1991. We have law of 12 of 1996, amended by 126 of 2008. We have one of the best legislations about the child in Egypt. This is in my point of view in dealing with children. Yet, before moving to the details of the law, I'm going to discuss the guarantees granted and offered by the Egyptian constitution without any discrimination between children and adults. All guarantees are offered to adult people concerning prosecution, as the rights of the rights to know why he's arrested, to know the reasons, and to have his own lawyer, and also the legitimacy of the punishment, and no crime without, and no punishment without a written legal text. All this, of course, is a part and parcel of the Egyptian constitution. Here I am going to talk about the rights of the child, and we have in chapter 8 of child law is related to the criminal dealing with the children. We have classified children under 12, they have no criminal responsibility under the age of 12, except when the legislature has said that when he is accused of a felony or a misdemeanor and he was from the age of 7 to 12, he may receive a specific procedure or punishment, like scolding or giving it back to the family or to the parents, or being put in a reformatory. Under the age of 15, we are not allowed to punish them with a restricted for freedom punishment. There is also some other procedure aiming at reforming and improving and rehabilitating the child, getting him back to society in a way with the so-called reconciliatory justice. And this is there in every country, but we don't have it in the Egyptian law, in fact. And also that is the reintegration of the child to the society, that you allow him to do is an apprenticeship or a specific profession. Then after being accused, after staying some time in a reformatory, he will be back to society, he will working in something else. As far as crimes are concerned, I have just heard a question some time ago about the Zena in Port Said, and the girl who was raped by a child who was under the age of 18. And in fact, most of the crimes committed by children are mostly they have been criminalized against. They are victimized rather than victimizers. Sometimes there are social and economic environments, social surroundings which put the harsh conditions for a child. Maybe if had he been born in a different place, in a different circumstance, he wouldn't have committed the crime. Maybe, but at the end of the day, legislature in Article 111 in Law 126 of 2008 related to children, a child shall be executed. Even this strict and tightened punishment must not be restricted. It must be. Actually, I'm not clear about that in Article 111. At the end, the legislator has aimed at rehabilitating the child and getting him back to society. As far as arbitrary detention is concerned, children under the age of 15 may not be arbitrarily arrested or detained, and they may be put in a reformatory to be under the supervision and the auspices of social workers, and for weekly reports to be submitted to the judge. And of course, instead of being imprisoned, they will be just put in the reformatory. When he is when it's seen by the judge that he is still to be detained, he may be not detained, but he may be under the reformatory, under the supervision of a reformatory. Also, there are specific procedures as stated in Article 101. There are 8 procedures. 3 of them are just effectuated and in practice. Being handed over to his parents, this is one thing, and the judiciary test, this is number 2, or the last thing is to be put in a reformatory. These are the 3 effectuated out of 8. Now we have Article 101, scolding and blaming, and training in an apprenticeship, being committed to specific duties, to do something related to the Egyptian public utilities, or to be put in a specialized or specific asylum. We have 3 out of all these judiciary tests, that is to be under the supervision of the social worker, under the Ministry of Solidarity and Social Solidarity, to see whether he is okay, to see how his behavior is, and to submit a report to the judge to know whether he is on the right way or not. All this is submitted and decided by submitted to the court and decided by the discretion of the judge. We have to be put in a reformatory something looks like being detained or being imprisoned, but the difference is that he's being under the supervision of the social solidarity and under social workers, and there must be programs for rehabilitation. As I said, this is not a punishment, this is not a penalty, but this is a precautionary and a protecting measure for the child, who is supposed to be suitable and appropriate and a good person for society, and we hope that he would not be back to this bad deed or he did. Now I think the 3 out of the 8 procedures are taken, 5 of them are not being applied. Take for example, being committed to a specific work, being obliged to do something or specific duties. There must be a collaboration between the Ministry of Justice and Social Solidarity to provide specific places, specific jobs for the child to be doing. For example, to work for public service, for example, for a child, for example, to work in a library, to work in a garden for a child, for example, who can help in gardening or something like this. We have a lack of places. There must be a collaboration between the justice and solidarity ministers, and we don't have places for this, so this is not in effect. This is due to the lack of potentials, or Yet we have the legislations, but it is a lack of potentials. In my opinion, it's both lethargy and lack of resources. We are dealing with the law as if we were employers. We don't have a clear vision how to effectuate what is being written in the text of law. It's just a very rigid text, and we don't know how to effectuate or apply it. Children from the age of 15 to 18, when committing any crime or any restricting for freedom crime, he receives a sentence, but in a commuted way rather than the one over the age of 18 or the adult. When he's imprisoned, for example, he will be, for example, in a lesser period than the adult one. Uh, Taking into consideration Article 17 of Egyptian Penal Criminal Code, and it is there in also Article 116 of the child. There is no civil lawsuit against the child is not accepted, uh, but it is not accepted against a child under the age of 18. And in that case, if a child is the defendant or the accused is a child in an imprisonment case or in a misdemeanor, there must be a lawyer. In the formation of also the court related to the child, specific restrictions have been set to forth to the court. As part of the court must be two social workers, one of them is a female at least, and before giving the sentence in a specific case, the opinion of social workers must be taken, which is consultative and advisory, but not binding to the court. And if there are any crimes with specific sum of money or fines, for example, to be paid by the child, and the child has no income, of course, resources, he must not be fined. But all other punishments, for example, when there is a fine, for example, the and if the judge is forced to do so for a confiscation and fine, there is nothing like this with a child, because the adult, when is unable to pay the fine, he will have to have it imprisoned. Uh, of course, fees. Child is also exempted from paying the fees before the courts. This is very important, and this is a summary of Law 126 of 2008 relating to the child and the role of the judges in, in dealing with the child. This Egyptian constitution has also set forth Article 80 of the Egyptian Constitution of 2014. This text has said every person under the age of 18 shall be considered a child, and there must be a specialized court for children or a family court, and the country shall be committed to establish and form a court or a family court or a child court. And he has also stated the important procedures. There are social workers, and it's established by the Ministry of Solidarity. For example, it is being guarded by a security guard, maybe, but a security guard is not supposed to interfere or to deal with what is inside. Also, this is the case of punitive reformatories. Sorry, if a child is being put in a reformatory or an asylum, for example, like Merck Reformatory, you just see the poster or outside. It is affiliated to the Ministry of Solidarity, but at the end it is affiliated to the Ministry of Interior, and all the supervisors are very interior, where they are dealing militarily and harshly with the children who are supposed to have good and better rehabilitation in all these reformatories and all these institutions related to the child, in any confinement procedures against the children. The problem here is maybe detaining the children in a specific place. There are no rehabilitation programs in such reformatories. as Doctor has explained, that social workers who are inside the reformatories are just working on a routine basis, on a red tape. They are not interested in the better way of how to behave with a child and how to deal with them. Social workers and all these people do not take into consideration whether there is a problem. They do not deal with the child in a proper way, and all psychological impacts on the children. Of course, all the complications that the adults suffer from, they just reflect them on the child, which have, its miserable impact on the child. Instead of having a child who is being stronger, he will be more violent, crueler, and in a revengeful manner. These are two problems. I have given some examples, prepared some examples related to the disparity.
لو الوقت يسمح اقولهم ولا
To the disparity of. I'm going to talk about some media, and we have some cases where children have received execution penalty, and that was in Mania, for example. Unfortunately, of course, as we said, it was abolished. The sentence was in absentia, so it was abolished. The judge just treats the evidence of reference and the proof of incrimination rather than the every single detail about the documents about the child. If I say that if a child is to the ministry of to the criminal court, if a child has committed a crime with an adult, he shall be referred to the criminal court. And in the state security, criminal problems, a child must be referred to the criminal court or to the state security courts. In these cases I am mentioning, the child was in absentia, receiving a death penalty. Of course, the articles were not very clear, and the prosecution was not given correctly or properly to the judge. Of course, there was a big problem, as I'm sorry to say, the judge didn't read the documents properly. We had also seen an under 7-year-old child, and he was taken from his home, and he was, of course, without a guard, an ID card or anything, and he was before the court, and it was taken to be a mistake that his name was taken to be similar to another person. And this was also, these types of problems are being taken in a country like Egypt. This shouldn't happen in a state like Egypt. We shouldn't have this disparity. We shouldn't have these problems in the Egyptian society. In a case, for example, a 16-year-old child, in a specific case, he was accused of raping another child, and the name, there must be a police investigation paper must be given to the prosecution, and we must take a permission or an arrest warrant from the prosecution. But if the officer goes to home and takes one of the child's, the family of the child as a hostage to oblige the child to go to the prosecution, and then he receives a sentence, and then there is an appeal against it, a child of 13 or 14-year-old, the acquittal punishment is being cancelled, abolished, and then he receives imprisonment. And in the first place, the child is not guilty, but they did not understand that the law has given the child an restricting for freedom sentence. Therefore, this acquittal must be, of course, taken into consideration. And what's important to say is there is a conflict and there is a misunderstanding of the Egyptian law. That's what he would like to say. Thank you, Mr. Muhammad. Let me ask you one question. Is it lethargy or a defect in the legislations? Because what you said, is it legislation? Is it negligence? in the implementation of law, or is it the unqualification or the lack of training for legal professionals, or not informing those legal professionals about these the misunderstanding about the law 126 of 2008? We have development in the children's activity. We have, I'm sorry to say, we have advanced texts. I'm sorry, but we have backwarded and we have weak implementation. I'm sorry to say, we should not look for more texts, legislative texts, but what's important is to look for procedures to teach law professionals about implementation or enforcement procedures. We must teach them what they have to tell them, that we have a lack of reconciliation, justice reconciliation justice. We should add this to the legislations. We, as Dr. Adil Medani has just explained at the beginning of the session, that he concentrated on the concept of punishments and the sanctions and the regulations governing the punishments. As is important, the qualification and rehabilitation are of paramount importance, is to train those working on prisons and those supervising prisons and those law enforcement bodies. We have to train them and teach them. We have 10 minutes in order to finish this second session. Mr. Magdi, could you please kindly continue? Thank you, Mr. Hazim, and thank you, your distinguished guests. I'm very pleased to have seen Dr. Adil Medani, Professor Adil Medani, after this long time. Yesterday and today, we are talking about the advantages of our constitution, and we say, what is the best law, and what is the problem here? The problem, in fact, is the lack of understanding about the laws. A proverb say, give me an unjust law and a just or a fair judge, then justice will be okay. So what is the problem? Why are we calling on the parliamentarians to amend? Why? Why do we amend? No, we do not need amendments. Do we need to change the infrastructure of understanding the laws? Are those in charge of the laws working with a theory of let's finish, or they are just fabricating things? Why is that? To take hostages? For example, if a policeman goes to arrest a child and he doesn't find him at home, is it possible to take one of his family as a hostage, to take a man? That was the case in Upper Egypt. That was in the past. Shall we refer to the past? Shall we have something that is not possible? Is it possible for a policeman to just avoid implementing the law? Is this the problem of the law or the problem of those in charge of enforcing the law? We must know exactly how to deal with the loopholes and all these problems related to criminal law. The death penalty has been mentioned twice in Islam. First, qasas, retaliation, and ridda or apostasy, that is to leave Islam. In ridda, or leaving Islam or apostasy, it's impossible. We give him a chance for 3 months, and then we give him another 3 months. So at the end of the road, it's not going to be applied. The other one is there must be a premeditated murder, which is very difficult. We have many philological studies and legal studies that we have to refer to and take them as a reference and authority. There are studies by Dr. Selim Al-Awwa, one of the famous Egyptian thinkers, about the apostasy or the ridda in Islam. This Dr. Selim Al-Awwa has reached the conclusion that this apostasy punishment, death punishment, is impossible to be applied. So we have to refer back to the philological points of view and to the studies about the death penalties about the children, or for example about women, males, and the expansion in the application of death penalty, for example. This will not work. What I heard from the distinguished guests and distinguished lecturers that the problem in Egypt is the laws are not changed, but laws are added to others. And sometimes laws are applied, let's say, old-fashioned laws, 1914, since the British occupation, are still in practice, are still applicable. Yet we need a revolutionary legislation. Thank you very much. My question to Dr. Adil Madani. Dr. Adil, you drew a comparison between Egyptian and prisons in Switzerland. What is the difference between them? My question, have you visited any Egyptian prisons? And in that fact, if you visited any, what is your evaluation for what is being stated in the media and its impact on the prisoner? I mean, the psychic or psychological impact on the one in prison, but not the one to be executed. I mean, a juvenile child, for example, or somebody who is charged with a criminal felony or something like this. Does this have an impact on his character, on the prisoner's character? We find him hating society. We find him having grudge and ostracized by society. So hates society and has antagonism against society. We have seen yesterday the discussion about a case yesterday. Remember the one of the superintendent when he was killed by somebody. Do you remember what happened? Yes, so it took yesterday, and he was killed because of the maltreatment of the superintendent. And you remember how the cleverness of the Court of Cassation, the judge at the Court of Cassation was clever, because he understood that the superintendent who was killed in the first place, who was the culprit in the first place. So, my question back to Dr. Adil, when you talked about the training, for example, of the children, the training of, those in charge of prisons, and those violations committed by the policemen inside the prison, for example, by secret agents or any other police rank. Dr. Adil Medani, I'm very proud of your views. What you have said is, of course, psychologically perfect, as individual differences are being eradicated, and there is a retardation for psychological health of the prisoner. What is the philosophy of prisons? How would I make a balance between somebody who committed a crime, and I would like to restrict his freedom, and at the same time to keep him psychologically healthy, mentally healthy? This is a difficult question, how to strike a balance between both of them. Second question is to Mr. Muhammad about the law child of 2008. As I have an experience with child reformatories in Egypt, I want to tell you that sometimes there are the dissemination or the spread of bad behavior amongst children. The children teach each other bad behavior. What are your measures to avoid this, especially that we have a big arsenal of laws, documents? I am working, for example, in quality assurance for education. First thing, I go to schools, I find all documents are there, but yet they are just papers without any practice. So, this, what are your points of view to evaluate this? I have been stunned about what you say about, for example, people who are being criminalized against or victimized against, like Zena, for example, the one who was raped in Port Said. Do you have any point of view to add more legislations that parents are held negligent for the crimes that the children are committing, in order to force the parents to take care more of their children? Of course, here we back to the causality philosophy. The child, of course, in the first place, he was victimized by the family, so the family must bear the burdens of this. So could you please call for a recommendation to have a pledge by the parents to take care of their children, or they will, or otherwise they will have the consequences of negligence? Let's go to the right now, and then we'll be back to the left. سؤالي إلى الدكتور، أنا أريد أن أنا أسأل حضرتك إذا ما كانت في فترة الزيارة إلى السجون حضرتك لقيت ناس ارتكبوا جرائم خطيرة وكانوا محكوم عليهم بالإعدام، وفي خلال الوقت اللي حضرتك قضيته في السجن هم غيروا طريقتهم وغيروا حياتهم وابتدوا يفكروا بطريقة أفضل، حضرتك نقدر نقول في الحالة دي ده ممكن يحصل، صح مش كده؟ إن الشخص اللي ارتكب جريمة تغير وهو بقى شخص تاني مختلف تماما لما دخل السجن، لان الفترة اللي قضاها في السجن غيرته. في الحالة دي لو احنا عدمناه هل هيبقى احنا قتلنا شخص تاني عن الشخص اللي ارتكب الجريمة؟ انا بسأل حضرتك لو حضرتك قابلت شخص تغير داخل السجن لانه مثلا اتعامل معاملة كويسة او بشكل تاني داخل السجن، انا مش بقول احنا في ايطاليا احنا عندنا مثلا بشكل مختلف للجناية، عندنا المافيا انتوا عارفين حضرتك حاجة خطيرة جدا في ايطاليا، في مثلا 20 30 40 سنة الشخص بيقضيها في السجن، والفترة اللي بيقضيها هذا الشخص في السجن بيغيرهم تماما. فانا عايز افهم من حضرتك لو هؤلاء اللي ارتكبوا هذه الجرائم الخطيرة ودخلوا جوه السجن وتغيروا هل ده بيحصل؟ شكرا. Mohammed Abdullah, a lawyer at the Egyptian National Organization for Human Rights. I would like to greet Dr. Adil Medani, especially that he mentioned the defects of the restricting freedom punishments, as it swipes away the character of the person and it leads to more moral problems and sexual problems in particular. When I hope that to add a recommendation that to add to the punishments in the Egyptian Punitive Penal Criminal Code, the one in France and in other countries, is the electronic supervision or surveillance rather than other punishments. For example, instead of for example, if I send somebody to be imprisoned for 3 or 6 months, he will have many problems. First of all, I'm going to break the terror of doing a crime, committing a crime, that he will be dealing with more serious criminals. This will also have impact, social impacts, miserable impacts, economic impacts. Maybe he may be fired from his work at a family. It may lead to divorce cases. In my opinion, I think, or I hope, that we should modernize new systems like electronic surveillance to instead of the 3 or 6 month imprisonment. That is, the child will have like handcuffs and he goes to home. He's going to be imprisoned at home from 9 p.m. to 6 a.m. in the second day. In that case, this will help two services. First of all, I'm going to commute the costs of the state, compute the imprisonment period, and not to take him to the prison instead of building new prisons. 90% of the countries resort, or I'm sorry, 90% of the punishments that given by the Egyptian prosecution also take place in the misdemeanors, which are from 3 to 6 month imprisonment. Why don't we resort to the electronic surveillance, or that is to reduce the number of people, and this will also help to reduce the costs and will not take the child to the prison. Also, there are other alternative ways. For example, I'm sorry, please. Thank you very much. I don't like knockdown. I don't like knockout strategy, but I'm sorry, we run out of time. Yes, good afternoon. Uh, I would like to differentiate between two types of punitive reformatories in Egypt. The first is when somebody is, there are productive prisoners or producers or go to prison, and those people will not have problems as they may learn apprenticeship or get apprenticed in the prison, and he may take some money even and get out of the prison later with a good profession, with experience that he will use in the rest of his life. But now we would like to concentrate more on the punishments that related to the guardianship, for example, and the types of crimes, for example. And this needs to change, and I think these need rehabilitation and qualification, and those especially who have terrorist ideas, extremist ideas, they need changes. Do you think, or I'm sorry, have you been invited to any prison where you could sit with those second category, I mean, and to see the type of ideas they have received that led to their being extremists? Or we as human rights organization, we pay many survey visits or field visits to the prisons, but of course there is a difference in the quality of the prisoners we meet or the quality of a terrorist prisoner. I think he doesn't care, he's indifferent about prison because he may consider it something that they make a cell inside the prison, for example, that they will bring together other prisoners and to polarize them to their ideas. I know that such people, they have meetings with sheikhs in order to correct their ideas, but I think this is not enough. Do you think that psychiatry can play a role with these prisoners to change their behavior, or at least to keep the rest of the prisoners from receiving such extremist or terrorist ideas? And do you think that how can psychiatry separate the prisoners inside the prison from these extremist ideas? We will take 5 minutes to Dr. Adil and 5 minutes to Dr. Muhammad. Dr. Adil, I'm going to remember all the questions. In my opinion, I think the philosophy of punishment or the philosophy of penalty has a main theme. That is, somebody has refrained from the rules of society and has been out of the norm and order of society. We would like to get him back to society, correct, proper, sound, unbroken, strong-headed, and not a focal point of corruption or a hideout or a hub for corruption. We want to get him back as an active participant in society. This is the main goal of punishment. We never seek to dehumanize somebody. What we seek is to deprive him of freedom, but, quote unquote, humanly. As I have been talking about the Bern in Switzerland prison, once some prisoners have been, I've been exposed to see some prisoners. One of them, I've met one of them, and when I see him, he is always handcuffed. He is handcuffed, yes. And I saw this man was chained like a boat chain, this heavy chained, and he was handcuffed by the chain around his leg, around his legs, around his hands, as if he were a wild, savage animal. Try to imagine. Why is all that? Why is all these difficult chains? Why don't we have just a normal handcuff? He will never escape. So this will create an counter-aggressiveness, aggression, and antagonism. He will never be good when he gets out of the prison. What is our role as psychiatrists? Is the following. In terrorism and other things, our role is, first of all, we are human beings with a specific particular idea. I know that a snake stings, doesn't it? And when I see a snake, I fear. and when I fear, I run away. It's a tripartite idea, sense, and behavior. A tripartite idea. So, first of all, when I see the idea, we all fear the snake, but somebody may come in the circus and say, I have a big snake, and he gives it to you and say, okay, why don't you have a photo with the snake, and then you take the snake. So the first thing is the idea. The idea may lead to the change of behavior, because when you are not fearful or afraid of a snake, I have changed the normal idea. Applicably, this is possible. So the first thing is, in this tripartite, to change the idea, which will in turn lead to the behavioral change. This, I amend, I adjust, I modify the idea, the attitude of the people, of the person. Here, sometimes there are irrational or illogical ideas. For example, for example, that people must love me or people must accept my opinion. This is illogical. For example, we as psychiatrists here, we say no. We try to adjust it. We say no, it's impossible that everybody will accept your view. And we give them examples, for example, very simple examples, that all people have agreed on two things to love. That is water and air. And water and air have no color, no flavor, no scent or smell. That means if you are like water and air, you will have no color and you will be like water and air. But no, take into consideration that you have people who agree and people who don't agree. And this is the way I convey it to the prisoner in order to change his idea. So the first thing is to teach them the culture of being different. The culture of, not the culture of wipe away those different. We will be different in religion, we will be different in science, we will be different in so many things, but what's important is how to deal with our differences, not with those who differ with us. So I have to teach him the culture of being different. If I changed his idea, I'm going to move to another point. Therefore, we can change sometimes. نقدر نغيرهم مش كل الناس يعني, or not all, but in some cases there are some people who will not be simply changing, but these are the minority and exception proves the rule. As if, for example, if I were a teacher, I would say that a pupil is not good, so I'm going to generalize it and to punish all the other pupils or students. No, exception proves the rule. Exception proves the rule. The rule, I mean. I said, I fully agree with anything that brings the one who committed the crime back to society, because the main goal of our philosophy is to get him back to the right track, not to deviate him, not to expel him, not to throw him out of society. It's called rehabilitation or reintegration of somebody into the society. Our strategy as an Egyptian institution, as a member of the 97 Egyptian coalition institutions, we are observing the problems that happen in the prosecution of children and or the legislations related to children, and we report it back to the officials. Now there are important points, 2 points in legal points. First of all, there are the committees of protection that are there in each governorate, and there are also subcommittees in every quarter of a governorate that observe and monitor the cases. and also delineates and provides the policies for every government that is provided to the government. The second point is police stations, prosecution, and courts when children are detained or, for example, or being imprisoned, and even the Ministry of Social Solidarity. We have so much called on more specialist social workers, for example, or psychological workers to deal with children, to observe and monitor the enforcement and the implementation of these punishments. We have also called for a reconciliation justice, and especially that the compensations should be given to the victimized, and also the reference justice. Also, for example, the victimized will receive a compensation, and there is also a punishment against the child that is to do something for the best of society. That is a two win-win situation. I give money or a compensation to the victimized, and I force the child to do something useful for the child, for society. So it's a win-win situation that will help the society, and which will help the child, the victimizer, as well as the victimized. Now that, thank you for your information. Thank you for your quick information. Thank you, Dr. Adil, and thank you, Mr. Muhammad. Dr. Adil, I'd like to say that we will immediately begin the last session in order to gain time. If you do agree with this, I'd like to give a very simple remark. I have been working for 16 or 17 years in the parliament.
كنت مسؤول عن متابعة البرلمان وحضرت
And I attended tens of sessions in the parliamentary subcommittees discussing legislation, discussing reports. And one of them is the Legislative and Constitutional Committee in the parliament. I have never seen in my 15 or 16 year experience, I have never seen that from amongst the invited, with those, I've never seen people invited who have no direct relations with the topic. For example, if we talk about the prisons, the prison law, I'm the Faculty of Arts. I am interested in democracy. I don't know anything about law, for example, but I have never seen that somebody like Dr. Adil, for example, somebody would come to explain to legal professionals the impact of these on the psychological aspects of the prisoners or the criminals and its impact on the society. I have never seen people from outside the legal profession to come and explain to the legal professionals the impacts of this. As I said, amendments are not just texts. In the past, we were saying criminals in the past, take him off, kill him, cut off his hands, and all this. But they have not taken into consideration the impact of this on society. So I fully second Mr. Alai's point of view with this, and really specialists other than legal professionals must be there, and they can help in explaining the philosophy of legislation to the legal professionals. Here, a last point is we must concentrate on courses to qualify and rehabilitate those working in reformatories, to teach them that here we are coming to just evaluate, just to improve the one, not to dehumanize the prisoner.